Good morning, everyone. I am Atul Choudhary, Assistant Professor at IIMT College of Law. And today, our topic is human rights and judicial endeavors for its protection. So, today we will discuss about that what are human rights, what are their interpretations, what are the background introduction, and what are the different interpretations of human rights have been done by the judicial system in India for the protection of human rights. Introduction. Human rights and judicial endeavors for its protection, justice delayed is justice denied. So what it typically means that if there is delay in the protection of human rights by the judiciary, it is equivalent to no justice at all. So this is very common that we all know. Human rights, a basic right is for all. They human rights is for everyone. It is universal and inalienable. These rights are not conferred by the law, but by virtue of humanity. It is inherited in every human being. Human right is not a new concept. It can be audited from the Vedas, Manusmriti, Arthashastra, and some other scriptures which discourse human rights. In various written documents such as Magna Carta of 1215, French Declaration of Right and Man and of Citizen 1789, US Bill of Rights 1791 asserted various individual rights. In the 20th century, the United Nations came into existence in 1945 after the Second World War. After 3 years, in 1948, UDHR, Universal Declaration of Human Rights, was presented to the world with 30 articles which awarded the first recognition to the human rights universally. Now, various international conventions, treaties, covenants, and domestic laws also emphasize on keeping human rights out of jeopardy. In the present article, vehemence is on how efficaciously judicial body acted to the protection of human rights. India and human rights. India is the largest democratic country and is also a signatory of UDHR. UDHR, that is Universal Declaration of Human Rights, safeguards civil, economic, cultural, political, and social rights. Indian Constitution shields human rights from peril in form of guaranteed fundamental rights. Same as human rights, these are inherited by birth. So we are here talking about the fundamental rights which are equivalent to human rights in Indian context. These rights cannot be amended as it is part of the basic structure of our constitution. Part 3 and 4 of the constitution put an obligation on the state to protect human rights, though part 3 is enforceable but not part 4. So we know that part 3 of the constitution is about fundamental rights and part 4 of the constitution is about directive principle of state policy. Fundamental rights are legally enforceable. That means you can go to the court for the enforcement of fundamental rights. But the directive principle that are in the part 4 of our constitution, they are not legally enforceable. You cannot go to the court against the government asking the government to take steps on directive principle of state policies. This has been decided by various judgments, various judicial interpretation, judicial judgments from the Indian Supreme Court and high courts, various high courts. But it is not that directive principles taught state policy are totally irrelevant. They are not totally relevant just because they are not enforceable. This does not mean that they are totally relevant. They are very relevant and they give power to the government, especially the directive principles taught state policy. They give power to the government, state government, be it uh, of the central government or any local authority, any state under Article 12, they give enough, they give power to work on directive principle of state policy. And also in various cases, it has been said to use the harmonious interpretation. That means not to, if it is possible, that not to deny, not to ignore directive principle of state policy DPSP in part 4 and to look more and more toward the fundamental rights. This is so harmonious construction. It says that fundamental rights and directive principles of the state policy DPSP in part 4, they need to be interpreted harmoniously so that they can both work together. The preamble of the Constitution also talk about the protection of dignity of an individual. Constitution directs the state to make endeavors for human rights protection. Under Article 32, people can approach the Supreme Court in order to avail the right guaranteed under Part 3, and Article 13 empowers the Supreme Court to declare any law void if it encroaches upon the Part 3. All this makes the Supreme Court guardian of these rights. So the Supreme Court is the guardian of fundamental rights. It is said the guardian of fundamental rights. Why? Because Supreme Court has the power to stop any law that is against the fundamental rights under Article 13 of the Constitution. Article 32, Clause 3 provides that legislature by law can empower any other court to protect these rights. In compliance of this, Parliament has ordained the Protection of Human Rights Act 1993. So Parliament brought a specific legislation for protection of human rights, that is Protection of Human Rights Act 1993. This act provides human rights means the definition of human rights it's given in Human Rights Protection Act, which is human rights means the right relating to life, liberty, equality, and dignity of individual, guaranteed by the Constitution or embodied in international covenants and enforceable by courts in India. The Act also directs to establish NHRC, which is National Human Rights Commission, and SHRC, which is State Human Rights Commission, and HRC, Human Rights Courts. So human rights is defined as rights that are related to life, liberty, equality, and dignity of individual. And it also talks about the establishment of NHRC, National Human Rights Commission, State HRC, SHRC, State Human Rights Commission, and Human Rights Courts. So National Human Rights Commission. Let's talk about National Human Rights Commission. Section 3 of the Protection of Human Rights Act 1993 put an obligation of establishment of National Human Rights Commission in compliance with which central government has constituted NHRC 1993. The central government, in accordance with Section 3 of Protection of Human Rights Act 1993, established a National Human Rights Commission. Protection of Human Rights Act 1993 also provide composition, function, and procedure of NHRC. All the procedures of the National Human Rights Commission are given in the Act. NHRC play a crucial part in the protection of human rights and keeping the faith of the common man in the criminal justice system. NHRC and Supreme Court can complementarily protect and improve human rights. A national commission can give recommendation to various authorities. It has provided recommendation in matters like health, education, police encounters, custodial death, guidelines for arrest, etc. National Human Rights Commission can either take suo motu action or on a petition filed before it. So it can take action on its own also on any matter, and the action of NHRC can also be initiated through a petition or a complaint. In 1993, the Commission had issued the guidelines regarding custodial death to all the state governments that in case of such incident, Commission must be informed within 24 hours, and this will be followed with postmortem reports, magisterial inquiry reports, videography reports on the postmortem, etc. Section 36 to put some limitation on NHRC, but Supreme Court in Paramjit Kaur versus State of Punjab construed this statutory provision that when the Supreme Court, by exercising its power under Article 32, refer the matter of infringement of human rights to the Commission, then the Section 32 Clause 2 cannot restrict Commission to act in accordance with the order of Supreme Court. Supreme Court said that Commission will be sui generis body to carry out the functions referred by Supreme Court, and this body is not circumscribed by any sort of conditions. So there are no conditions on the body. In the instance case, in a case, Supreme Court observed that no statutory provision can curtail the Supreme Court to exercise its power, and there is no reason why this commission cannot comply with the order of Supreme Court, that is to take into matter of violation of human rights. Along with Supreme Court, NHRC makes endeavor in the protection of human rights. Let's talk about State Human Rights Commission. A state government may constitute a body to be known as the State Human Rights Commission with the name of the state, of course. So that is Uttar Pradesh Human Rights Commission, to exercise the powers conferred upon to perform the functions assigned to a state commission under the Act. Section 21 of the Protection of Human Rights Act 1993 empowers the state government to establish a state human rights commission. The act also provides the power and function of the commission. It has two similar function as NHRC, but it can deal with the matter enlisted in the list 2nd and list 3 of 7th schedule of the Indian Constitution. The deterrent point is that only 19 states have constituted NHRC, so not every state has constituted its own human rights commission. In 2004 and 2005 report, the NHRC set forth the list of states which constituted the SHRC in their respective state. NHRC also reiterated that the protection of human rights can be ensured if all the states set up the commission, and it must be in compliance of Paris principles. In DK Vasu versus State of Bengal, the court asked why there is no state human rights commission in various states even after 2 decades of the enactment of Human Rights Act 1993. Supreme Court conspicuously asked how the capital of the country does not have any human rights commission. Court construed the word may of section 21 that this may do not give an option to the state. The word shall and may do not imply discretionary or mandatory in all the cases, but it must be interpreted on the basis of the object of the section. Justice T.S. Thakur and R. Bhanumati directed the state government to constitute a state human rights commission, and Supreme Court elucidated that the state has no option but to comply with the order in 6 months. In the year 2016, Center depolared Supreme Court order by stating that the Delhi is not a state but union territory, and the law behests the state to establish the Human Rights Commission, not to union territories. So this was the argument given by the government that Delhi is not a state; it is a union territory. So that's why they have not established a Human Rights Commission. And they said that therefore Delhi will go along with the Human Rights Commission until the law embedded. The bench headed by Justice T.S. Thakur reiterated, do you fancy, that's what the judge said, do you fancy that union territory are utopia ideals where there is no human right violations? Do you expect people from other territories like Tamil Nadu, Pondicherry to come all the way to Delhi to fight their cases before the National Human Rights Commission? Regarding amendment in the law, Justice T.S. Thakur said that there is no need for an amendment in the law to be made by Parliament to set up a Human Rights Commission for Delhi. We will give a legal interpretation to the existing law if necessary. The Protection of Human Rights Act 1993 was amended in 2006, which mandated all the states to establish the State Human Rights Commission. According to the report of NHRC, Human Rights Commission in state will bring forth better governance, as the better governance and human rights go parallelly. Establishment of commission in states will ease access of the people to better protection of human rights. Human Rights Codes. Section 30 of Protection Human Rights Act directs all the state government to an agreement of opinion with CJI of the High Court of respective state to recognize the Court of Session as a human rights court for the speedy trial. Section 31 provides that states shall appoint a prosecutor or an advocate with not less than 7 years experience of practice for the purpose of dealing with the case of this court. In the year 2015, in the same DK Vasu case, the Supreme Court also directed to comply with this provision to specify the Human Rights Commission, Human Rights Court. It was ascertained that no attempt is made by the state to consult with CJI of High Court of the respective state for scrutinizing the viability of the sessions code for specifying as human rights code. In the year 2019, again, Human Rights Commission, during the hearing of the Punjab State Human Rights Commission versus Jatram, NHRC put forth that except few state, no state complied with the order to specify or set up human rights code. The bench said that the setting of these codes does not require any additional appointment of judges or infrastructure. Still, judgments of the court is not excluded. Supreme Court has issued Chief Secretary to show cause that why such direction need not be issued. Supreme Court jurisprudence on human rights. Supreme Court recognized as the guardian of the fundamental rights. So its crucial function is to protect these rights. We are the signatory of the international conventions on human rights. Therefore, our constitution is embodied with human rights in the form of fundamental rights in part 3. The concept of separation powers make the judiciary independent from the other two organs, which allow the judiciary to uphold the rule of law and protection of human rights. In India, judiciary exercises its power of interpretation of Part 3 efficaciously in order to trigger advancement in the human right protection. Supreme Court is India is endowed with the power of the judicial review, and Article 32 gives increment to this power by allowing the court to review all the measures taken by the government and pronounce it void if it abridges the Part 3 of the basic structure of the Constitution. This power of review keeps all the organs of the state within its limit as conferred by Constitution or any other law. In the case of infringement of the right of Part 3, person can directly approach to High Court under Article 226 and to Supreme Court under Article 32, which itself is a fundamental right. So, taking the remedy of Article 32 and Article 226 is in itself a fundamental right. Article 32 is the cornerstone of our democracy, which makes the Supreme Court protector of fundamental rights. According to Article 32, Clause 4, this right to approach will be suspended if the emergency is proclaimed. How Supreme Court advanced the protection and promotion of human rights. We see the case of Keshavananda Bharti versus State of Kerala. In this case was heard by the largest constitutional bench of 13 judges. In this case, court has gifted us the doctrine of basic structure. So the doctrine of basic structure was given by the Supreme Court in the case of Keshavananda Bharti. Court held that this principle, that is the doctrine of basic structure, is inviolable, and accordingly, the court outlined that power to amend is not bottomless but limited. This case overruled the Golaknath case, and the court said that Parliament Act will be counted ultra vires if it tries to rewrite the whole constitution in the lights of its power under Article 368 of the Constitution. This view of Supreme Court protected human rights fundamentally. In habeas corpus case, which is the ADM Jabalpur versus Shivakant Shukla case. In this case is a black point in Indian historical judgment. In this case, 4 out of 5 judges held that all the fundamental rights will remain suspended during emergency. Justice H.R. Khanna gave a dissenting press judgment which paved the way for the rule that state cannot deprive anyone of the right of life and personal liberty without due process of law. Personal liberty. Menaka Gandhi case. In the present case, the court gave the wider interpretation of the word personal liberty. The court considered that for the depriving a person of personal liberty, requisites of Article 14 and 19 must be fulfilled, as Article 14, 19, and 21 are interconnected. Maintenance case, which is the Sahabanu case. Supreme Court granted maintenance to Sahabanu and protected the rights of Muslim women beyond the personal law. But Muslim community considered that this verdict of the court encroaches Muslim Sharia law. Therefore, Parliament ordained All India Muslim Personal Law Board. Interpretations of Article 20. Apex Court has widely construed Article 21. The word life is explained in watershed judgment of US Supreme Court that life is something more than mere animal existence. Supreme Court of India said that the right to life is not mere physical existence, but the right to life with dignity. Article 21 includes non-payment of wages to the worker will be denial of the right to live with human dignity. Supreme Court held that sexual harassment at the workplace is the right to live with human dignity, and it is also the violation of Article 14, 15, and 21. Right to shelter, right to know, right to livelihood, right against solitary confinement, right to free legal aid, and right to health, right to privacy, etc. They are also the violation of Article 21. All these are appended as an inherent part of Article 21 by the Apex Court while exercising its power of interpretation. Third gender case. In year 2014, Supreme Court recognizes the third gender, transgender as the third gender and protected their rights. And the Triple Talaq case, 2017, Supreme Court of India, uh, majority judge by 3 raised to 2 declared Triple Talaq as unconstitutional as this practice jeopardizes and violates rights of Muslim women in all facets. Sabrimala Temple. Supreme Court allowed the women entry in Sabrimala Temple that is of age of 10 to 50 years as the devotion cannot be subjected to the gender discrimination. Homosexuality. Supreme Court in the year 2016 decriminalized Section 377 of Indian Penal Code on the ground that it goes against Article 14, 15, 19, and 21 of the Constitution. This verdict of the Supreme Court only decriminalizes homosexuality under Section 377. Rest of the law will remain the same. Article 7, after 72 years of homosexual people is off the hook, and they can also enjoy the right as heterosexual people. Adultery. Supreme Court said that husband is no more master of wife, therefore pronounced the adultery is no more crime as it violates the dignity of women, hence infringes Article 21 of the Constitution. Court also elucidated that adultery is still ground for divorce and it will be considered crime criminal if it leads to abetment of suicide. Adulteress could be prosecuted under Article 306 of IPC. Let's talk about the analysis. Historical verdicts show that judiciary made endeavors for protection and promotion of human rights, but we cannot say that this is infallible. However, it can be stated the Supreme Court exercised its power of interpretation so well that it widened the scope of right, which made it more expeditious for everyone to enjoy their rights. In India, the judiciary is not superior, but as we have constitutionalism, we invoke the judiciary is independent and all the bodies have to comply with the order of Supreme Court for the welfare state. Our law directs that the government to establish certain organs for the protection of human rights. In compliance of this, NHRC at union level and few of the states set up State Human Rights Commission. Law provides that the state should establish the district human rights courts, but there is non-compliance in this regard. Supreme Court has directed the state government to establish State Human Rights Commission and human rights courts. However, most of the states do not act in accordance with the same. This lacuna on the part of state deletory is serving justice on part of the society, is not serving justice on part of the society. It is not easy for every person to approach National Human Rights Commission anywhere in the country in order to avail their rights. Law since 1993 requires every state to constitute State Human Rights Commission and human rights courts in their respective territory to accomplish the objective of speedy remedy to all. The controversial point is that law does not set forth the procedure of the State Human Rights Commission to deal with such type of complaints, and the Act does not mark the jurisdiction of such report regarding the offence of violation of human rights. This ambitious factor must be looked into promptly by the lawmakers so that vigilant protection provided to the human rights and the aftermath of the already existing law does not display. Thank you, everyone.